Welcome everyone to this morning's session on data protection and freedom of information for HE. It's great to see so many people here. My name is Andrew Galley. I'm a partner in the information law team, and I've got Claire here as well, who is a legal director in the team. So in terms of what we're going to cover off today, we're going to start off by looking at subject access requests. We'll then consider some practical issues around freedom of information requests, in particular the recent ICO fine issued to the police force of Northern Ireland. We'll then look at cybersecurity and some tips around managing a data breach before finishing off with everyone's favorite topic, international data transfers. So these are things that we think are important, and to be honest, they probably reflect the four areas that that constitute most of the advice that we give to our HE clients. But as ever, we are do feedback. If there are things that you're sort of sick of us talking about, let us know. And equally, if there are things that you want us to mention or cover that we haven't done previously, that would be great. Just let me know. Just drop myself or Claire an email after the session. So before we get into the detail, I just wanted to spend a moment thinking about where we are in terms of the data protection piece, the big picture. So as many of you will know, the Conservative government had planned to reform data protection law through the Data Protection and Digital Information Bill that had been set to make a number of changes. For example, it had planned to reduce some of the perceived red tape associated with data protection compliance, and to make it a bit easier to use personal data compliantly for a number of purposes. Now, the bill fell by the wayside with the election. It didn't go through. In the King's Speech, Labour announced their plan to introduce the Digital Information and Smart Data Bill. Doesn't exactly roll off the tongue, but that looks at first glance to be quite similar to the previous bill. It'll have similar objectives. So it's about using personal data to drive growth in a safe way. It will apparently give the ICO additional powers and make it easier to use personal data for research as well, which I know will be highly relevant to many of you. I get the sense, though, that that Labour's bill won't go quite as far as the previous one. Perhaps Labour are a bit more concerned about maybe not getting adequacy, or rather losing adequacy with the EU. Okay, so I'm going to hand over to Claire, who's going to talk about subject access requests.
Hi, everyone. Good morning. Thank you for joining us. I see we've got a brilliant turnout, so thank you very much for coming along this morning. My work is increasingly being taken up by advising on subject access requests. We've seen a steady growth over the last few years in SARs being made. They are normally made in the context of grievances and complaints, occasionally also made in the context of litigation. And they are very popular as a kind of a way, I think, of seeking information that the requester thinks it might be able to use against your organization to help them with, as I said, complaints, grievances, that type of thing. Often the requester is not successful, shall we say, in finding what they want, often in my experience, because what they want actually doesn't exist, which can make SARs feel quite futile, I think, and quite frustrating to have to deal with. But I'm afraid that the Information Commissioner's Office and the courts are still relatively data subject friendly, shall we say, which means that it is quite difficult, in my experience, to refuse to respond to a SAR using either the manifestly unfounded or the manifestly excessive exemptions, which allow you to refuse entirely, which means that for the majority of SARs that come across your desk, you will have to provide a pretty substantial response. The good news is that colleagues and I deal with so many subject access requests that we are quite au fait with how to make them easier to deal with. I won't say easy to deal with, I'll say easier. But there are definitely top tips that we can share with you. And that's kind of the purpose of the time I've got allocated today, really. I don't have time to go through kind of everything you might possibly want to know about subject access requests and how to respond. So I've picked out some of the things that I think it's helpful for you to know ahead of dealing with subject access requests. And I imagine some of you actually are probably in the midst of responding at the moment. The first thing I wanted to mention, and the first thing on the slide, is team effort. I sometimes find that clients come to me, and I normally in the sector speak to the data protection officer or information governance manager, someone like that. And often it's apparent to me that this person has been given a subject access request to respond to, and they haven't necessarily been given adequate support across the institution. And the reason that support is helpful partly goes back to what I was mentioning a moment ago around SARs are normally made for a reason. They're purpose blind. You don't need to justify why you want to make one. There's normally a reason behind it. And for that reason, I get a little bit worried when there's just one person dealing with a subject access request, because that person might not know the context in which it's been made, which makes it far more difficult for that individual to strategically think about how to respond to the SAR. And most importantly as well, makes it more difficult for them to think about what exemptions might need to be applied. So my first message really is SARs are often, normally in my experience, a team effort. So whilst you might have one person, normally the DPO, leading on the management of the SAR being responded to, that doesn't mean you can't get input from other individuals around the institution. And sometimes you will need to do that because information might be ambiguous. You might not know the context in which it's being made. The context in which the information has been written can change the meaning of it, for example. So do make sure that you are getting the support you need from your colleagues regarding responding. The other reason to make sure that you're not alone, as it were, in responding to SARs is information security. I will talk about this far more actually when I talk about freedom of information, but I think it's also worth mentioning in the context of SARs that really you should have a second pair of eyes on every SAR disclosure that goes out, because it's so difficult for one person to make sure that they have sufficiently removed third-party data where appropriate. And the last thing we want to do is risk you having a data breach. I'm increasingly seeing requests made by third parties as well. Normally, it's union representatives and solicitors in the context of the work that I do for the higher education sector. It's absolutely fine for someone to make a SAR on behalf of somebody else, as long as they have that person's authority. The thing I want to flag here is that you do need to be satisfied that the data subject, the individual whose data is being requested, has genuinely authorized and understands what they've been authorized. Please don't think that just because a letter has come from a law firm, that that law firm necessarily has done things correctly. I've seen some really shockingly bad forms of authority, shall we say, given to the sector over the years. So don't be scared to push back if you think that the authority maybe isn't what it needs to be. So, for example, make sure the authority actually refers to the information being requested. Has the person, when signing the form of authority, genuinely understood what they're authorizing? If you have any doubts, don't feel bad about pushing back, because ultimately it's the third party's responsibility to show you they've genuinely got the authority of their client or their representative. Something else where I kind of see institutions kind of get things a little bit muddled is asking for ID. There tends to be a blanket approach taken to asking for form of identification. Now, don't get me wrong. In many contexts, asking for ID is vitally important for information security reasons. But that doesn't mean that you should blanket be asking for form of ID. In addition, you need to make sure that you are not asking for more information than you actually need to satisfy yourself the request has genuinely been made by the person it's purporting to be made by. So, for example, if you get a SAR from a current member of staff using their university email address, chances are you don't need to go back to ask for a copy of their passport. That would be excessive. But the amount of times I actually see this, it's kind of getting one of those things now where I'm kind of sounding a bit like a broken record. So it's not a blanket approach here. If you have, for example, a subject access request form that you encourage people to use, it's not a requirement for them to use it, but no problem actually having a form. Again, make sure that form is drafted so that you're not asking for excessive amounts of quite sensitive data. Think about it, if you're asking for copies of passports and driving licenses, there's an information security risk there as well, isn't there, if that information ends up getting lost and you didn't really need it in the first place in a lot of cases. So again, think carefully about, take more of a nuanced approach, I suppose is the message here regarding asking for ID. The next bullet point on the slide says taking a strategic approach. Now, as I mentioned, SARs are normally made in the context of some form of dispute, grievance, maybe an employment law issue, that type of thing. Whilst it is the case that you are obliged to provide personal data plus supplementary information subject to exemptions, there is still some flexibility. It's not a black and white exercise, so do feel free to think strategically. And this is where you might need to, coming back to the first point around team effort, get input from other individuals who are maybe leading on the employment side of things to get their input in what is in the best interests of your university when responding to the subject access request, because there are grey areas. And when making a judgment about where, in the spectrum of that grey area you want to take, which approach is best, that is a strategic decision to be taken, not necessarily just by the DPO, but with support from other members of the university as well who are involved in the particular matter. I'm increasingly seeing requests being made which are incredibly lengthy. I think I dealt with a request a few weeks ago that was about 5 pages long. The person was asking for a huge amount of information, and the institution in question held a large amount of data on this person. Where that is the case, so where they are asking for a huge amount of data, you hold a huge amount of data on them, you are allowed to go back to ask them for clarification. I'm a big fan of going back for clarification, because even if you think the requester might not comply with your request for them to clarify specifically what they're after, going back for clarification allows you to manage their expectations that because they've made such a broad request, your obligation is to do reasonable searches. And that means that they might not get specifically what they're asking for unless they ask you or provide you with information to allow you to do more targeted searches. I think a huge amount of dealing with SARs at the moment, in my experience, is this management of expectations around the requester's entitlement, explaining to them kind of upfront, they're going to ask for a large amount of data. Your obligation is to do reasonable and proportionate searches. And so unless they can be quite specific, they might not get what they're entitled to. It's kind of a way of encouraging them to help you, to help them in some ways. So as I said, big fan of clarification, which isn't to say that clarification is appropriate as a blanket rule in all circumstances. There are situations where, again, coming back to this taking a strategic approach, where you might want to take a more nuanced approach and, for example, just do reasonable and proportionate searches upfront rather than asking for clarification. And that could be for all sorts of reasons. It could be because your relationship with the requester has so far broken down and it's irretrievable that actually just getting them something that's compliant and kind of leaving it at that is the best approach. So it's strategic. There's no black and white rules here. But as a general rule of thumb, I am quite a big fan of asking for clarification because it allows you to manage expectations around your obligation being to do a reasonable search for their personal data. And lastly, on this slide, I just wanted to briefly mention manual unstructured records. The vast majority of you on this call will be public authorities for the purposes of FOI, which means that the rules around what is personal data are slightly broader than they are for the private sector. So do bear that in mind when dealing with subject access requests. That it's not the case that like the private sector, you're only concerned with electronic information or information held in a filing system. Because of FOI and the interaction between FOI and data protection, it is broader for you guys because manual unstructured records also contain personal data, because otherwise they wouldn't be protected by the personal data exemption under FOI. But the good news is when dealing with SARS, the requester has to provide a description of data if they want it in a manual unstructured record. And there are also certain exclusions from SARS as well that it's worth familiarizing yourself with as well. So just wanted to flag that because that's something that people miss from time to time. That being said, 95%, maybe even more, of the SARS that I've helped the sector with have been for purely electronic information, because I think most things these days are electronic. Where it's historic information, it might be different, but current employees, current students tends to be mostly electronic. But don't forget that the rules for you guys are slightly different around manual unstructured records. So next slide is preparing the response. I mentioned a moment ago that your obligation is to do reasonable and proportionate searches for the personal data. Please do bear in mind that you are searching for personal data of the requester, not every reference to their name. Now, I know that requesters are increasingly putting in their requests. I want you to find me the data that has, my initials on it. Sometimes people refer to me by this nickname and sometimes people misspell my name like this. That's fine. The requester's entitled to put that in their request if they want to. But you are not necessarily 100% obliged to follow their instructions. So for example, if someone says my initials are, I don't know, whatever X, and you know that if you do a search across your system for their initials, it will bring back 100,000 records. That's not reasonable and proportionate. You're not required to do that. So don't think that you have to kind of black and white blanket follow what the requester is saying around how you do your searches. The requester is entitled to ask for what they want to ask for, but ultimately it's your institution that has to decide and justify as well doing reasonable and justify how you did reasonable and proportionate searches. I think bearing in mind what is personal data is really important in an employee or former employee context. Just because I send an email or just because I'm copied into an email doesn't mean that email contains my personal data. It contains my name, but under a SAR, I'm only entitled to a copy of my personal data, not to the original, a copy of the original document containing that personal data. So think about when you're dealing with a SAR, think about where personal data of the requester is most likely to be found rather than just references to their names. So I get clients sometimes call me up in a bit of a panic saying, Claire, we've got like 100,000 records. We've no idea what to do with this. It's absolutely ludicrous. At which point I say, take a step back, think about where their personal data is most likely to be found. What filing systems have you got in place? Which staff are most likely to hold their personal data as opposed to just emails containing their name? Again, coming back to this think strategically, think tactically point that we mentioned a moment ago. I'm also increasingly seeing requesters mentioning that they want their personal data contained in things like WhatsApps and social media. Do make sure that you have policies in place that prevent staff members from using things like personal WhatsApp for work reasons. It will just make your life so much easier. The ICO's view is that unless you have good reason to believe that personal data is held on a personal device in a personal communication channel, you are not obliged to ask that employee for that information to search their device or to search their personal information, because that would be a violation of their privacy. But it's much more helpful if you can point to something in a policy, in a procedure, an acceptable use policy, for example, an information security policy, saying to your staff, you are prohibited from using personal WhatsApp for work reasons. You're prohibited from using personal devices. This is where work personal data needs to be held. It makes your life so much easier when you come to do those searches. It also means, I think, that there's less of a risk of staff members putting inappropriate things in writing, in recorded form, that might be disclosed under a SAR, because they've got a greater awareness of the fact that if they're using personal WhatsApp, that doesn't necessarily mean it's outside of your university's controllership. It gives more of a kind of an overview to them of the kind of importance of making sure that information is held centrally, where you, for example, as DPO, information governance manager, etc., are able to more easily locate that data when responding to a subject access request. Last but not least, I want to briefly mention a new case that came out, I think about a month or two ago now. Harrison and Cameron is the name of the case. And this was a case essentially where the judge had to decide to what extent the requester was entitled to information about recipients. So as I imagine most of you already know, under a subject access request, people are entitled to a copy of their personal data, plus certain supplementary information. The supplementary information is broadly similar to what goes in a privacy notice. One of the things that it says in Article 15, which is the right to make a subject access request, is recipients or categories of recipients. Now, the GDPR, being quite ambiguously drafted, or the UK GDPR, I should say now, doesn't specify whether it is recipients or categories of recipients, and if it's which of those two it is, or who gets to decide if it's recipients or if it's categories of recipients. Is it the controller that gets to decide, or is it the requester that gets to decide? The judge in this case said that actually no, the requester does get to choose if they want recipients, specific recipients, rather than just categories of recipients. So don't forget about the supplementary information when preparing your response. So recipients, for example, would be who sent an email containing the personal data of the requester. I see sometimes people deal with subject access requests and they think that the approach to take is just to blanket reject all third-party names. That's not necessarily the right approach, because the requester is entitled to information about recipients of their personal data. Now, there are still exemptions, and we're going to go through the third-party data exemption in a moment in some detail. But I do just want to flag, whilst the personal data of the requester is the main thing you will be focused on, please don't forget about the supplementary information. So this case is quite clear that people are entitled to know about the recipients of their personal data, subject, as I said, to exemptions. They're also entitled to know, the case didn't deal with sources, but the recipient, so the requester even, is entitled to know information about the source of their data as well. So don't forget about that. And the GDPR, the UK GDPR actually says any information available as to the source of the data, unless they were the source of it themselves. So it's a relatively high bar there. So please don't get too redaction heavy when you're dealing with things like emails. Do take a more nuanced approach there. Making SARs easier in practice. So as I said, colleagues and I have quite a few top tips. My main one is records management, which I know can be quite dry and sound a bit dull, but it's so important. Because if you as DPO don't know where you're most likely to find personal data to respond to a SAR, it's going to be much more difficult for you to make sure that you have done those reasonable and proportionate searches that you need to do. So staff training here is vital. Staff training that they shouldn't just be keeping everything in their inbox forevermore. If something's important, it needs to be filed somewhere. Staff training as well is also really important around things like inappropriate comments, making sure that all staff at your institution, at your university, know that if they put something in recorded form, in writing, in a voice note, in a voicemail, in a video, that could potentially be disclosable under a subject access request. So the staff training there is really, really important. Staff training as well needs to cover things like how to recognise a subject access request, because as hopefully you will know, under the UK GDPR, SARs don't have to be in writing. They can be made orally to any member of the university. So making sure they are passed promptly to you is really super important. I've said do proper searches here, and I've kind of covered this off already, by which I mean, please just don't do a blanket search for the person's name across your entire system, because it will reveal hundreds of thousands of records in most cases. Think strategically, think tactically about who is most likely to hold that information. Kind of do targeted searches rather than broad searches. It will make your life so much easier. Please as well document your reasoning behind why you searched, where you searched. Because if the ICO get involved and ask you awkward questions like, well, hang on, how did you miss this? Because occasionally you might miss things. As long as you can show the ICO that you did genuinely do reasonable and proportionate searches, the fact that you miss something isn't necessarily the end of the world, because you're not obliged to search in every conceivable location where their personal data might be found. That's too high a threshold. It's reasonable and proportionate searches, which still needs to be pretty extensive. If you've documented how you did them, it will make it so much easier for you to deal with ICO complaints about SARs. And then lastly on this slide, stick to your retention periods. Obviously, keeping data for a long time in certain situations is very important. It helps you defend against legal claims. There might be very good reasons around safeguarding data, keeping that kind of thing, sensitive data. But I mentioned a moment ago about staff members just keeping everything in their inbox forevermore. That's not your friend when it comes to dealing with subject access requests, because that's when you end up having to churn through loads and loads and loads of emails, for example, that frankly the university might not even needed. But now you're having to prepare them for disclosure, which is time consuming and possibly risky depending on what's in them as well. So do make sure that you've got some form of procedure in place to stick to your retention periods. Next slide, please. Right, I mentioned mixed personal data or third-party data a moment ago. So this is an area where I think there's still some confusion in the sector. Mixed personal data is essentially where you cannot give the requester their personal data without revealing information about somebody else. And that includes that the other person is the source of that data. So if one colleague of yours, for example, writes an email to you about another colleague, the colleague that wrote the email is the source of that data, and the person they're writing about is the kind of the subject, as it were. So you've got mixed personal data there. In some cases, there's no problem just redacting the name of the other person to protect them. But often in my experience, it's normally possible to work out, or the requester's capable of working out, who the source of the data is, even if their name is redacted. So in that situation, we have to take a more nuanced approach. And it might be the case that it's not actually possible to give the individual their personal data without revealing the information about the other person, whether that's because of the source of the data or the information also relates to them in some way. So where you've got this mixed personal data, the rule is that you only disclose it if you have the consent of the other individual, or if you don't have the consent of the other individual because A, you didn't ask for it, because you're not obliged to ask for it, or B, because they said no, then the test is it reasonable to disclose that data, the mixed data, without the other individual's consent? Now, I want to stress just for a moment, you are not obliged to ask for the consent of the other individual. The ICO say it's best practice in most cases. However, I am actually going to disagree a little bit with the ICO there, because in my experience, it's often not appropriate to let the individual who is maybe the source of the data know that the person has made a subject access request. So do think carefully about what you are doing around asking for that consent. I also want to make it clear that, in my view, when we're talking about consent under the mixed personal data provision, it's not the same threshold as it would be under the GDPR, UK GDPR, because it's possible under the mixed personal data provision, for strictly speaking, for the individual to refuse their consent, but it still be reasonable to give the data to the requester. I would caution against doing that, but strictly speaking, how it's drafted. So consent there, confusingly, I think is subtly different to consent under the UK GDPR, because consent under the UK GDPR, when you seek to rely on consent, you are giving them, the individual, all of the control. Whereas under the mixed personal data provision, it's more a factor to take into account. But like, as I said, in the majority of SARs that come across my desk, because they're so complex and so horrible, it's often not appropriate actually to let the other individual know that a SAR has been made. So as I said, have they consented? If they haven't consented, is it reasonable to disclose? So what's reasonable? So you have a wide margin of discretion here. That was confirmed in a case a few years ago under the Data Protection Act 1998 called Dr. B and the General Medical Council. Wide margin of discretion, which means that as long as you can justify that your decision was in that margin of discretion, it doesn't matter that I might have taken a subtly different view, or the ICO might have taken a different view, or the courts might have taken a different view. As long as you can say it was in the margin of, within the reasonableness kind of margin of discretion, you're okay. This is where it's really important to document your reasoning. Make sure you've got records that can back up your thinking around the application of the mixed personal data exemption, because it is quite a subjective one. Now, there's no concrete, definitive, exhaustive list of factors, but there are certain factors listed in the Data Protection Act. That includes, and this is the one that comes up the most in my experience, a duty of confidentiality owed to the other individual. So, for example, is the personal data contained in a witness statement that somebody else gave? And if they did, was there a duty of confidentiality owed to the other individual? As I said, any express refusal of consent by the other individual, assuming you sought consent, is a factor to consider. It's not definitive, but it's a factor. And again, guys, I would caution against going against the wishes of the other individual, because you don't want to open yourself up to a complaint there. Think about the consequences of harm as well for the other individual. Might distress be caused to them if this personal data about them is disclosed to the requester as well. And then the starting point often is the data subject already aware of the information about the other individual? Because if they're already aware of the information about the other individual, it's much more difficult to argue that it shouldn't be disclosed. Right, that was my whistle-stop tour of some of the factors to think about regarding subject access requests. And I'm just going to briefly now cover FOI. Next slide, please. Now, in covering FOI, a few weeks ago when we were thinking about this webinar, I was going to think about some different things. And then, as many of you will be aware, the ICO issued a fine to the Police Service of Northern Ireland at the beginning of October. And because this is such a monumentally important, I think, enforcement action by the ICO, because it's such a large fine, I did want to talk about this in some detail. So, for those of you who aren't aware, in 2023, the Police Service of Northern Ireland responded to an FOI request and accidentally disclosed a lot of information about employees that they shouldn't have disclosed, that should never have got out there in the public domain. And the consequences of this information being disclosed are actually quite severe. So the headline, really, the takeaway is, you need to have appropriate organizational and technical measures in place to make sure you are not disclosing information under FOI requests. You must be able to demonstrate, should something go wrong, that you had those appropriate technical and organizational measures in place. The ICO have quite helpfully produced a checklist regarding spreadsheets in a Word document that you can roll out at your university. I'm going to do my best to try and link to that checklist in the chat function, so you guys have got a copy of it. But you can quite easily find it if you go to the ICO website and look at that, the information that they've published about this particular fine. So under the GDPR, UK GDPR, you're obliged to put in place appropriate technical and organizational measures. When we're thinking about FOI disclosures, those organizational measures are things like staff training, written policies, written procedures. This won't come as any news to you because you guys will be all over this already, I'm sure. Just wanted to mention, though, a couple of points which I think are a bit less obvious, but in my experience can be really valuable here. One of them is, pay attention to the near misses. So, as you all know, under the UK GDPR, you have to keep a log of all data breaches, even if they're not reportable to the ICO. But I'm also a big fan of making sure you're paying attention to where you didn't have a data breach, but you came that close, because there's really useful learning there as well. So pay attention to the near misses too. Also want to make it clear that you need to make sure you have a culture within the team that is responsible for dealing with FOI. That means that you guys are quite open with each other about where there were near misses. We don't want a situation where people are too scared to come forward with suggestions as well. So this isn't kind of a top-down thing. Information security around FOI disclosures is very much one for the entire FOI team. And last but not least, just wanted to mention that the main thing I think here is you need to be able to demonstrate, if something goes wrong, that you did have these measures in place. So make sure you've got something in writing that you could show to the ICO should something go wrong when you're responding to an FOI request. I'm going to leave you with that now, and I'm going to pass over to Andrew, but I'm happy to take questions. So put any questions in the chat box and we'll cover those at the very end.
Great, thanks very much, Claire. So moving on then, I'm going to take a look at cybersecurity and data breach management. And the reason why I wanted to cover off this topic is really twofold. The first is that the greatest area of risk under data protection law relates to data security. and personal data breaches, of which cyber breaches, cyber issues are a significant part. So it's an important topic. And second, there's just so much chat right now, both in the news and in terms of what's coming further down the line with regards to cybersecurity. For example, I'm sure every week, I'm sure we all see stories in the news about some catastrophic data breach that's got everyone very sort of concerned and very excited. In addition to that, the government plan to introduce new laws, the Cybersecurity and Resilience Bill, that's going to place extra obligations on some UK organisations with regards to cybersecurity that go beyond what can be found in the UK GDPR. So it's an area that sort of has heightened focus and heightened security right now. So over the next few slides, I'm just going to sort of just have a quick reminder of the cyber basics. Then we'll look at some how some of these issues might play out in practice. So under GDPR, again, going back to absolute basics, when it comes to data security, your obligation is to put in place appropriate technical and organizational measures to safeguard personal data. So technical measures are things like network security, using appropriate encryption, and so on. Organizational steps refer to things like staff training, policies, and so on. And these issues crop up in all sorts of contexts. For example, Claire just talked about the importance of these points in relation to freedom of information requests and making sure that you don't have any sort of hidden data in spreadsheets. Now, there's a bit of a problem with data protection law in that if you counted all the pages in the GDPR and in the Data Protection Act, it runs to over 1,000 pages. So there's an awful lot there. And yet the part that deals with data security runs to less than one side of A4. So there's a real lack of detail in terms of what you need to be thinking about. And I think that demonstrates more than anything else that GDPR is a principles-based regulation, and it's up to each organization to think about what sort of works for them. So if you're looking for the detail of what you need to be thinking about in terms of cyber risks, the ICO has lots of helpful guidance. But in addition to that, the National Cyber Security Centre, or NCSC, has lots of really helpful resources. So the NCSC, this was a government body set up in 2014 to provide advice and assistance to UK organisations on cyber risks. And the NCSC have a number of tools available. For example, they have an early warning system that will apparently tell you if your systems have been compromised. They also have lots of technical guidance for organizations on cyber risks and on how to safeguard your systems. In addition to that, they've got a number of resources covering the organizational side. For example, they have a model cybersecurity training module that you can ask staff to complete. And whilst that obviously doesn't sort of reflect the complexities and the nuances of how universities might handle personal data in practice, it's a really great sort of starting point if you're thinking of producing or writing your own data protection or cybersecurity training for your own staff. Now, the other reason why it's important to pay close attention to NCSC guidance is that the ICO will look at it very carefully when deciding whether or not to take enforcement action following a personal data breach. So the biggest ICO fine yet under GDPR was given to British Airways, and if you look at the ICO decision notice, and it is well worth a read, you'll see how they sort of how they would look at the NCSC guidance and they would sort of compare how British Airways stood against that guidance and where they felt British Airways was lacking. Final point in the slide is that I know that some universities are looking at or have introduced information security management systems, which sort of provide a more holistic framework to introduce controls around data security that sort of cover everything from policies, management involvement, training, and so on. And I know that there are some HE-specific ISMSs based on common standards, such as ISO 27001. Okay, can we have the next slide, please? So I'm just going to look at some of the risks that have cropped up in the work we've done recently. So I think at the top, probably of everyone's sort of cybersecurity worry list, I think we've got phishing. So we're all very, very busy. We have no time. We sort of skim through emails very quickly, and people exploit that by sending emails that might encourage us to click on a link or open an attachment that will sort of extract our data or ask us to put in our credentials. So I think phishing is probably the #1 risk, particularly on the data breach work that we've been involved in. And phishing emails are getting more and more clever and more complex. So just give an example. A paralegal in our team received an email that was apparently from me, asking her to get in touch with me as a matter of urgency. And it's not obvious from our website that the paralegal works for me. And so somebody had taken the time to try and sort of work out who at BWV might sort of work closely together to give the email that sort of veneer of authenticity. Another closely related risk is relates to what are called spoofing, email spoofing. So that's where you make an email look like it's come from a trusted source. And spoofing emails come in various sort of shapes and sizes. For example, somebody might buy a web domain that looks very, very similar to the domain that you use. It might be sort of one character different, or might end in .org or something else, to make it sort of, at first glance look like it's come from the same institution. It's apparently possible to spoof the entire email address. So even if the email address matches exactly to the email address of someone you trust, it's still just about possible that it is come from a third party. So, so even if you check the email address, always just be mindful that it still might have come from a malicious source. Closely tied into that point, and the risk area is a lack of staff training and awareness. So it's really important to make sure that staff are trained on data protection. And as Claire alluded to, it's not just a question of sort of forcing people to sort of listen to someone talk about data protection for a whole hour. Deliver training and engagement in an innovative way. For example, here at BWV, our IT team will sometimes send test phishing emails to check whether people have been paying attention, to see whether people are prepared to click on the links, and if they do so, then they'll be asked to carry out further training. Now, the NCSC have said that those sorts of test emails, it doesn't recommend them, because it seems to suggest that might sort of create a disconnect or a barrier between sort of staff and the organization. People might be annoyed if they feel that they're being tricked. But my view is if it's done in the right way, it's a really great way of getting people engaged and getting people thinking about and just increasing that awareness around phishing emails and the like. And it's also important to make sure that your training is backed up with the appropriate policies. Make sure that your policies reflect how you do things in practice. For example, they reflect the specific home working arrangements that you have in place. They reflect your sort of approach to encryption. They've got to be relevant to how people are expected to use personal data in practice. Now, obviously, AI is sort of affecting all aspects of our professional lives, how we sort of interact with people, how we get stuff done. But perhaps inevitably, we're seeing some threats resulting from AI. For example, historically, phishing is often quite easy to spot a phishing email because the language used wouldn't always be that great, and there might be spelling mistakes. It might just look a bit clunky, a bit weird. But one of the things AI is very good at is writing sort of things that sound very good, that look very plain English. And so we're seeing more sort of phishing emails that look like they're better written and they're more articulate. Now, we've also been focusing on external attacks here, but don't forget a personal data breach doesn't just sort of relate to external attacks, and you should just be very careful about what people are uploading to AI platforms, particularly generative AI such as ChatGPT. And I'd be really careful before uploading anything that might contain personal data, because you're not sure, obviously, what the platform is going to do with it. It might sort of be ingested into the model. It might be used to train the model. There's even a story that with an early version of Google's AI platform, back when it was called Bard, that it was possible to see what people had put into Google Bard by doing the appropriate keyword searches in the Google search engine. So make sure that your use of AI is secure. The platform should be your processor, so make sure that you have the appropriate controller process agreement in place, and that you're satisfied as to data security. I also think it won't be too long before people are using AI to make malicious things such as viruses even more clever and even more sophisticated. I think right now we've got the technology to produce a virus that would, for example, sort of read the contents of people's inboxes, sent items, to get a picture of the person so that they can sort of produce a fully bespoke phishing email to make it sort of even more hard to spot. So a number of risks with AI. The other thing that's cropped up a lot is just issues around suppliers and supply chains, and the new legislation that I mentioned a moment ago, the Cyber Resilience Bill, is in particular going to focus on suppliers in the supply chain, on managed service providers, to require IT providers to be more robust about their cybersecurity, and will likely put in place obligations that go beyond GDPR. So obviously we share personal data with all sorts of suppliers. We entrust them with our personal data. So it's really important to do due diligence on them, to make sure that they're going to handle your personal data in practice in a way that you would like. They're going to keep it secure. So here at VWV, for example, we use something called BitSight that will sort of do it'll do a risk report on the supplier using information generated from lots of different sources, just so that we can sort of be satisfied that the supplier is is secure from a cyber point of view. And if ever a supplier had a cyber breach, then obviously we could point to that. We could point to what we did to our due diligence, that we checked that they were sufficiently secure. Also check the contract. So most suppliers will be your data processor, and the GDPR places very sort of prescriptive rules and obligations around what must be included in a contract between a controller and a processor. So make sure that the appropriate processor terms are included in the contract as well, covering things like your right to audit, data security, and obligations on them to keep your information confidential. Question I'm often asked is this: is if a supplier suffers a personal data breach, who is liable? Is it the university, is it the supplier, or is it both? And what the GDPR says is that essentially is that anyone who is in any way responsible for what's gone wrong is potentially liable for 100% of the damages to data subjects. So imagine you had a situation where there's a data breach. It was 99% your supplier's fault and 1% your fault. Then the individuals could come after you for 100% of their losses. So it's really important for that reason to make sure that that you've done everything, you've got the contract in place, and that you've carried out your due diligence. And also check the contract as well, because suppliers are very, very good at putting clauses in place that really limit or exclude their liability. And it's not yet been fully tested in court about to what extent a limitation of liability clause would be enforceable in relation to a personal data breach. But I wouldn't necessarily risk it, and just make sure that you're comfortable with the limitations and exclusions of liability in your contracts. So moving on then, what sort of things should you be thinking about if, despite all your best efforts, a personal data breach has taken place? So in terms of the steps to take immediately following a breach, I think perhaps the most obvious one is make sure that you have contained the breach, make sure that you have plugged the gap, plugged the hole, so to speak. You'd be surprised by the number of data breaches where the organization is confident that its systems are secure, but where the attackers still have ongoing access to systems and personal data. And in that context, I'm always slightly nervous about sort of organizations that sort of rely on their sort of internal assurances around sort of cybersecurity. For example, if your IT team confirm that they think that the issue's been fixed, there's also risk around sort of people marking their own homework. And there's no harm in sort of bringing in external experts just to check that any breach has been sort of addressed, and also to look out for any sort of wider breaches and making sure that those are covered off as well. If you do decide to make a notification to the ICO, I also think it's best to think about things strategically. And a question I also sort of put to clients is what's the purpose of making a notification to the ICO? What are our objectives? And I really think there are three. First objective is obviously you need to make sure that you've discharged any statutory obligation to notify the ICO of a personal data breach. But the second objective is really this: is your ICO notification is really your opportunity to set out all the things that you want the ICO to take into account in mitigation. So it's really a plea in mitigation. For example, I've been mentioning all of the measures that you already have in place around data security or the training. If you've had a member of staff who's done something really silly, and you can point to a policy that says don't do that, that's fantastic. Quote that policy, because that demonstrates that you had appropriate measures in place with regards to what went wrong. So the objective is to sort of encourage the ICO, to persuade the ICO they can just close their file, not sort of launching a more involved investigation into what happened. And the third objective is this: it is, insofar as we can, make sure that we're not saying anything that would prejudice your position further down the line. If, for example, there was litigation, if someone brought a claim, because your ICO notification is not subject to legal privilege, so it's potentially disclosable under a freedom of information request, or indeed disclosable in litigation should as part of litigation disclosure rules. So I sometimes see, for example, people refer to a data breach. People use language such as data breach. Well, I wouldn't do that. I would say data incident, data concern. It's quite possible to have a personal data breach without breaching data protection law. For example, in the thing I just mentioned, where something went wrong, data was compromised because a member of staff hadn't been following policy. So I would, if you can, make the point that although this has happened, you don't think you've breached data protection law because you had all these measures in place to keep personal data secure. Also, we're thinking about notifying individuals. You don't have to notify unless what's happened is a high risk to them. So it's a higher threshold compared to ICO notification. And also be thinking about who else to notify. For example, are there any other regulators that you might want to sort of to inform, such as the OFS, in addition to any ICO notification? Okay, could we have the next slide, please, Natalie? Thank you. So I just want to finish off then just with some thoughts on international data transfers. Again, this is an issue that we're getting lots and lots of questions on. There are some misconceptions, so I just want to address some of those. So just by a way of a very brief reminder, an international transfer or a restricted transfer, as the ICO call it, can only lawfully take place if one of three conditions are satisfied. The first is that the destination country has an adequacy finding that allows you to share personal data to that country. For example, the EU member states, South Korea, and some other countries have the benefit of an adequacy finding. If there's no adequacy in place, then you need to check whether there is an appropriate safeguard in place as well. And the safeguard that usually applicable is to contract on one of the standard sets of clauses produced by the ICO for international data transfers. There are two sets of clauses. You've got the IDTA, or International Data Transfer Agreement, or the ICO's addendum, which works as a bolt-on to the EU standard clauses and allows the EU clauses to work in a UK context. If you are using either set of standard clauses, you also need to do a transfer risk assessment. There is a template for that available on the ICO website. And the third condition that lets you transfer personal data is to rely on an exemption. The exemptions are pretty limited, but there are some that apply. For example, if it's a life and death emergency, if a member of staff has fallen ill whilst overseas and the hospital they're at needs their information about their health, then it's no issue to provide that information. I wouldn't be asking the hospital to sign an IDTA or anything like that. So transfers in practice. So I think the first step is really just to be thinking about what is and isn't a restricted transfer. So for example, if you allow an overseas supplier to have access to your systems where the data stays on university systems, for example, they might access your data through doing a screen share. Is that an international transfer, does anyone think? Well, the answer is yes, it is, because even making information available to somebody in a different country counts as an international transfer. But actually, this is a really good safeguard that you can put in place. So if the overseas party doesn't actually need to take a copy of the data, making sure that the data stays in your systems, on your servers, is a good safeguard, notwithstanding the fact that it still counts as an international transfer. What if you had an employee checking their emails whilst working overseas or on holiday overseas? Is that an international transfer? The answer is no. And that's because for it to be an international transfer, the information's got to go to a different controller or processor. So providing they're working for you, then that's not an international transfer. But obviously, you would make sure that they were only accessing their emails in a secure way, whether that's through a VPN or through a visualization platform such as Citrix. So you just need to make sure that the access is secure in the usual way. How about this? Sharing personal data with a student based overseas, is that an international transfer? In most cases, no. So as I mentioned, it's got to go to a separate controller or processor. So if you're emailing a student with their coursework results, for example, the fact that they're based overseas does not make that an international transfer. The position is slightly more nuanced with regards to transfers to the USA. So first, there is now, and has been for a year or so, a partial adequacy finding for the United States. So you need to check that the recipient has signed up to the UK extension to the EU-US data privacy framework. So if you go onto the privacy framework website, put in the name of the person you plan to transfer the data to, you can see whether they've signed up to the scheme. If they haven't, then you will need to put a safeguard in place in the usual way. That will usually be the IDTA or the addendum. However, you don't need to do a full transfer risk assessment. You can rely on the assessment that the Department for Science, Innovation and Technology did previously, just a document that you've that you are relying on the DSIT's assessment without needing to do a full transfer risk assessment. And my final sort of tip, I suppose, is just take a risk-based approach. International transfers happen all the time. If, for example, you're emailing someone else, a fellow researcher in a different country to see if they're interested in taking part in a research project, that's an international transfer. But I bet you don't always have a safeguard in place covering that. So be thinking about the risks, be thinking about what's risky, what's less risky, and that will no doubt inform your approach to international data transfers.